I wanted to wrap up today with a little bit of a segment on Ghislaine Maxwell. Ghislaine Maxwell is somebody who we've been sort of dabbling on. We've covered this case here and there. And the reason why I'm so interested in this case is because she has some just behemoth attorneys working for her. I don't even want to know what their cost, but I am very curious as to what they're doing and how they're going to be defending this woman. So I've been following it for some time just to figure out sort of how they structure things. I'm always trying to learn from other attorneys and see, man, that's a good idea. Maybe we can take that and use that for something that we do. Now, I've never represented anybody as high profile as Ghislaine Maxwell for charges like she faces on a federal level, right? This is a very high profile case. She's got a ton of money. And so she's got just, behemoth attorneys who are out there working on her case. And so I've been very curious just to follow along. And it's been a hard case to follow. This is not one of those that we can just sort of read the court documents and I can go, oh, I see what's going on here. That argument. So it's sort of like, building a house. Okay, we're going to paint that this way and put that finish over here and buy a couch over there. And you can do that with criminal law. You can say, okay, it's this defense and this case and this argument and due process here and whatever. And so we kind of have been following along Ghislaine's case, but most of her case is under seal. It's confidential. It's not disclosable. This is what I'm talking about. This is a motion that she recently filed, and we don't know anything that's in this paragraph. What are they talking about here? And this has kind of been the same thing that's been going on for a long period of time. And now it looks like the judge may be taking some of this away. We may be able to see what is going on behind the scenes. I'm going to show you what we're talking about. But this comes from one of her, so what they've been battling about. There were 2016, there were depositions where Ghislaine Maxwell was being interviewed in a civil claim by Virginia Guffrey, who you may have seen if you've watched any of this stuff on Netflix. Not a real good series in my opinion. It was very emotional and not particularly legally interesting, but some good backstory there if you want to go check out that series on Netflix. I digress. The point here is that they were arguing about releasing and unsealing some depositions that took place in 2016. A deposition is it's a formal court proceeding. You're on camera. Everything is being recorded, transcribed. You're under oath. And so you got to be honest about this stuff. Well, there were these depositions that took place, and there were some hard questions apparently for Ghislaine Maxwell, who was Jeffrey Epstein's number two, allegedly helped him, what's the word? Nurture, curate. I can't think of the word. It's on the tip of my tongue right now. But whatever it is, she's grooming. There it is. Grooming underage individuals to basically be, sex slaves for Jeffrey Epstein. Pretty gruesome stuff. Now, what she's talking about here, we don't know, because during the deposition in 2016, these questions came up. They had some arguments about them. The different higher level courts turned around and said, yeah, you got to answer those questions. So she came back down. They did answer the questions. And now the courts are trying to open up those records. The allegation here from Miss Ghislaine Maxwell and her defense team is that she made these statements under the belief that they were going to be sealed and confidential and protected forever. Now that you're opening them up, that is a violation of her rights, right? She made them with these guarantees of protection, but now that you're trying to open them up, you're violating that. She wouldn't have made those statements if you knew that they were going to be opened up. And so what they're talking about here in this document that I'm about to read you is their request that the judge continues to keep it sealed. They've been fighting over this stuff for a long time, and they're saying, you got to keep it sealed. Here's why. If you open it up, there are other people, not just Maxwell, who are going to be harmed by this information getting out. So presumably they're talking about they're talking about it as it's consensual sexual activity that she is engaged in, and presumably we can't tell what they're talking about because it's all blacked out like this. We can't see it. But the concept here is that there are other people who are involved in whatever that consensual activity was who might be harmed. And therefore, if they were to release this stuff open, if they were to unseal it, those people would be legitimately harmed by it. So let's read this. This is where they're making their argument that all of this stuff should stay under seal. Relying on the confidentiality protections of the protective order, Maxwell declined to invoke her privilege against compulsory self-incrimination and agreed to testify at the April 2016 deposition. So she's saying, we entered into an agreement, a protective order. We didn't invoke her privilege against self-incrimination. We didn't plead the fifth. We agreed to testify. because of the confidentiality protections. And then in that deposition, all of this stuff happened. Nobody knows what that says. Okay, this is kind of the curious part. Following the deposition, Guthrie moved to compel Maxwell to answer additional intimate and personal questions that she had previously declined to answer. In support of the motion, Schiller assured the district court that, quote, such questions are entirely appropriate in the discovery phase of the case, particularly where any answers will be maintained as confidential under the protective order in this case. So at the time, contemporaneously with her conversation, they were saying, yep, all of this is going to be protected. It's not going to come out. Now, look again. This is the next slide. Look at all this stuff that's blacked out. We can't see it. It's all redacted. The district court granted the motion in requiring Maxwell to answer highly intrusive questions, quote, relating to her own sexual activity and her knowledge of the sexual activity of others. The court held that Maxwell's privacy concerns are alleviated by the protective order in the case. In other words, the court is making sure that the information that you are detailing during the deposition, we're going to make sure it's protected. It's not going to get out. So don't worry about that. Talk about what you're willing to talk about, because it's going to be confidential. Now, not so much. And they're saying you're violating a prior agreement. Secure in the belief that the protective order would be honored, Maxwell appeared at a second deposition and answered hundreds of pages worth of questions about what is this? And someone else, what is that? From the very first question, Maxwell discussed, redacted. She was asked, redacted. Next sentence. She was also asked, redacted. We can't see any of it. What are they talking about? What's so important about this? It's killing me. What are they talking about? All right. Here is the order that came down from district court. This was filed yesterday, February 8th, page 1 of 3. Not a long order. It says, in response to Maxwell's counsel's letter, in ordering the continued sealing of its order on January 19th. So there was a prior order. So this judge has slowly been sort of opening the box a little bit, letting some of this stuff out, and then they're going back through this. And you can look this up in the court record. It's pretty interesting, actually. I think hundreds of pages. I'm not sure how many pages, but they have basically this table in a Word document, and they're going through and they're saying, okay, this paragraph, this sentence, we want it sealed, and they give a reason. Next one. We want this sealed. Here's a reason. Next one. This one is not important. Don't need it sealed. Next one. This one was already made public. It's irrelevant, for like 100 pages. I mean, just a ton. They're analyzing every single sentence, every single syllable, every single comma is being argued over in this criminal case, which is not particularly common, right? This is a little bit out of the ordinary. And now the judge has said that this is, some of this can be made public. Some of this can be released, but they're going to be weighing a couple different factors. They're going to be deciding whether or not the public has a presumption and a right to know versus protecting her privacy. So you've got these two competing interests going against one another, whether the public has a right to know versus whether Ghislaine Maxwell has a right to privacy. Pretty compelling interest at each other's throats. So let's go back to this order. It says Maxwell's testimony was pertaining to private sexual activity with consenting adults, and the testimony and identifying information of a non-party does, so that's other people who were not there, who have not been considered for unsealing, the court considered, as it did during the last round of unsealing, the reliance of these parties on the case's protective order. So this is kind of a botched paragraph. I didn't like how that was written, but it says here, as Maxwell points out, the Court of Appeals recognized that the third-party reliance on the protective order warranted the continued sealing of some materials in this case. So Maxwell in her motion said, yes, Court of Appeals noticed that there are third people here. You know, if you unseal this stuff, it just doesn't hurt Maxwell. It hurts other people who are part of the depositions. And so, yeah, you may want to keep some of that stuff secret. In considering for unsealing the materials at issue in its January order, the court also considered this reliance when it undertook its particularized review. And so that's where they're going through that table, hundreds of pages, and just, detailing what was done in the deposition. Concluded that some portions of this case's materials should remain under seal. So some of that stuff was under seal. Now we get to some law. Reliance on the protective order itself. So they're talking about, as I sort of frame this out, Ghislaine only made these statements because she thought she was being protected, that it was going to be confidential. And what this court is saying, yeah, but that doesn't just on its face per se, that doesn't just automatically outweigh the public's right to access the deposition. Okay. In unsealing the summary judgment, the Court of Appeals redacted deposition responses concerning intimate matters where the questions were likely only permitted and the responses only compelled because of a strong expectation of continued confidentiality. In recognizing this reliance interest, the Court of Appeals did redact some of her testimony related to her consensual sexual activity with adults, but it unsealed testimony relating to purportedly non-sexual massages, finding that the presumption of public access was not outweighed by the private interest in sealing this portion of her testimony. So what they're doing is they're just breaking this down sort of paragraph by paragraph, line by line, and they're saying this is protected because it's closer to consensual sexual activity with adults. This is less protected because it's a non-sexual massage. And just going through the deposition item by item. Here is the final page of this order. We have one more. Consistent with the Court of Appeals directive, the court considered the reliance of Ms. Maxwell and others in the order and directed materials unsealed where this reliance interest or other private interests did not outweigh the presumption of public access attached to these materials. So in this order, the judge is just saying, look, weigh those out, okay? Balance those out, and then we'll decide what should be released and what should not. There was a second order that also came out. So when this was coming down, Ghislaine and her attorneys, they filed a motion to reconsider, which is basically asking the court, hey, we know you ruled this way, but we really want you to reconsider that. Okay, here's why. You missed this, you missed that, you missed this. And so that's what this next order is. We're going to go through it quickly. It says, before the court is Ms. Maxwell's motion seeking limited reconsideration of the court's order, which is, look how much, we're not unsealing a lot. They're fighting over a lot of, very little information. This court order is unsealing 20 lines of Ms. Maxwell's July 2016 deposition transcript from page 112, line 17 through and including page 113, line 12. Very specific. Ms. Guffrey and non-parties Julie Brown and Miami Herald Media Co. oppose the motion. So they want this information to come out. Maxwell is saying we want it protected. Guffrey and others saying we want it out. For the reasons described below, Ms. Maxwell's motion is denied. Court goes on. She submits the court should reconsider its order unsealing on the basis that this portion of the testimony falls within the category of adult consensual activity that warrants sealing. To the extent that the testimony was not sexual in nature, it was outside the scope of permissible deposition questions. Number two, Ms. Maxwell's reliance on the confidentiality assurances of the protective order outweighs the public interest in her testimony. The court already said, nah, we don't think so. Because public release of this section of testimony will make it more difficult for Ms. Maxwell to suppress this testimony as evidence against her at a criminal trial. Right? And that's probably the biggest one there. Might be something in there that they really don't want out. The court declines Ms. Maxwell's invitation to consider its order unsealing portions of her testimony. First, Ms. Maxwell's motion does not meet the reconsideration standard. She points to no change in the law, no new evidence, nor any clear error on the court's part. So you need those things in order to be successful on the motion. The court already weighed the evidence. Just because you don't like their opinion doesn't mean you get to go in and ask them to change it again. You got to find something else. Change in the law, clear error on the court's part, new evidence, any of those things. Maxwell doesn't have them. She made in her original objections to the unsealing of the 3 points she raises for the second time in her motion. The court considered each argument already heard it. Accordingly, the presumption of public access is somewhat less weight than for a dispositive motion. Nevertheless, it's important that the public interest in monitoring federal courts' exercise of their Article II powers, that the public reviews the documents. Public access to certain parts of this transcript is outweighed by Ms. Maxwell's countervailing interest in resisting disclosure of details. Goes on. Let's see what else we have. All right, we got second, and more importantly, there is no reason to unseal this portion of the testimony. It does not relate to private sexual activity of consenting adults. There is no reason not to unseal this portion of the testimony. It's a pretty important word there. It does not relate to the private sexual activity of consenting adults, but only to massages. Miss Maxwell's privacy interest in such testimony is minimal, and as the court determined when it unsealed this portion of the testimony, any private interest she has in sealing this portion of the testimony does not outweigh the presumption of public access that attaches to it. And then third and lastly, while the criminal court acknowledges her interest in a fair criminal trial, Ms. Maxwell can argue all her points to the presiding judge in her criminal trial, as she already has. See her memorandum. She'll still have all the rules of evidence at her disposal and procedure, just like any other criminal defendant. To the extent that Ms. Maxwell can show at her criminal trial that the government improperly obtained this section of her testimony ahead of time, she can argue about whether the sanction of suppression is warranted. For these reasons, her motion for reconsideration is denied. Signed again by the same judge, Loretta Preska, Senior United States District Judge, New York, February 8th, 2021. So, this is one of those that it's kind of hard to have an opinion about because you don't know what they're arguing over. You don't really know what is that. Right? It's hard for me to come in here on here as a defense attorney and say, well, this is a good fight worth having, because I don't know what they're talking about. But they are putting a lot of effort into this. They do not want this to come out. If you go back and look at the court docket, they've been fighting over this for a long time. So it's just a couple paragraphs in there, but what does it look like? And let's take a look at the entire memorandum that her team submitted. This is from Ghislaine Maxwell. This is what it looks like if all the pages are spread out. And look how much of this is just redacted. Even like from the table of contents, redacted. Introduction, redacted. Major redactions across the board. Whole block paragraphs of stuff that is just excluded. Look at this over here. 2 paragraphs over here. Variety of sentences all the way throughout. So this case has just been interesting because we just don't really know what they're doing, because everything is under seal. Her attorneys are being extremely aggressive. None of the public access records are available. They're all redacted, and the courts are upholding a lot of it until now. So we'll start to see if any of this continues to come out.